Hi everyone, we're going to get things started here in just a few minutes. I'm going to give people a couple more moments to sign on and join us, so bear with us just a little bit longer. Thanks. All right, good afternoon everyone, and thank you for joining us today. My name is Allie Shulman, and I'm the coordinator of communications and marketing here at the SFIA. Before we get started, I want to quickly remind everyone of several important SFIA items we have on our radar. First, and most importantly, I'm asking each and every one of you to participate in our State of the Industry survey, which will be included in the follow-up email for this webinar. The survey will take approximately 7 minutes to complete, and your responses will serve as a great benefit to the overall industry, as it will provide an even better understanding of the sports and fitness marketplace and corporate environment. Survey responses also provide the foundation for future SFIA reports, webinars, and presentations. So please do your part to improve the industry, and in return, your business will also greatly benefit from our research. So please take a few minutes today to fill this out. Thank you. Second, for anyone who is part of the SFIA Soccer Council or SFIA U.S. Golf Manufacturers Council, or some of you know it, USGMC, please note your January meeting time. All other SFIA sport councils have already met over the last few weeks. If you're part of the Soccer Council, you should know that you're meeting at 2:30 today. That is in 30 minutes. So hopefully you're in Baltimore right now if you had planned to attend. The SFIA Golf Council meeting, please note that you will be meeting at the PGA Show in Orlando on January 21st, and we hope to see you there. Next, I would like to remind everyone that National Health and Fitness Day is just around the corner on March 10th and 11th. If you're an active lifestyle advocate and are interested in decreasing the cost barriers to physical activity for families across America, join us in Washington, D.C. on March 10th and 11th as we head to Capitol Hill to meet with congressmen and women as we garner support for the FIT Act. The FIT Act allows individuals to use pre-tax dollars to cover activity-related expenses. This would be a huge success for our industry, and we would love for you to join us this year. Please visit passfit.org to register. Also, the annual SFIA, NCAA, and NSHS Team Sports Rules and Management Conference will take place on April 13th and 14th in Indianapolis. SFIA councils will meet on April 13th, and April 14th will be a full day of educational presentations regarding industry insight, risk management, and single sport breakout sessions. Lastly, registration for the 8th Annual SFIA Industry Leader Summit opens today. If you register before March 1st, you will save $200. We can promise you that this will be the lowest deal available all year. So register now. You can go to www.sfia.org/calendar to reserve your spot. With that, we're going to get started. I want to welcome everyone to today's webinar, Ring in the New Year Lawsuit Free, a review of California employment laws that affect the fitness industry. We have two guests joining us today from Carothers DiSante Freudenberger LLP. Tim Freudenberger, founding partner and chair of CDF's Class Action Defense Litigation Practice Group, and John Giovanni, partner are here with us to talk about important new California-related legislation, key judicial decisions from 2019, and other developments those in the fitness and sports industry should know as we head into 2020. Tim and John, as experts in California law, are here to offer valuable suggestions to help make sure you are in compliance with all of the new and existing laws to avoid costly litigation in the first place. If your sports or fitness company has locations in California, you are sure to find great benefit. With that being said, we will be doing a live Q&A following your presentation. There is a question bar on your screen where you can submit questions to us all throughout the presentation, and then Tim and John will answer them once they are finished. Also, just as a reminder, the webinar will be recorded, so if you wish to access the presentation and its slides after the webinar, you will be able to do so through our website. And with that, I would like to get things started and turn it over to Tim Freudenberger and John Giovanni.
Thank you, Allie. Thanks for that introduction, and welcome everybody to this webinar relating to a review of California employment laws that affect the sports and fitness industry. We're glad you've all joined us today. We have an hour here, so we want to get right to it. We're going to discuss, as Ali said, some of the key, not all of them, because there are too many to discuss in an hour, but there are some key legislative developments in California from 2019, some critical judicial decisions that impact California employers. We're going to go through some of those and give you some recommendations on how to navigate around those to try to avoid litigation. And as Ali said, we'll be happy to take questions at the end of our presentation here. So I'll turn it over to John to start it off.
All right, thanks, Tim. So I am starting off with our new California laws, and we're going to start off with a bang, arguably the most controversial piece of California legislation of 2019, which is AB, which is Assembly Bill 5, dealing with independent contractors versus employees. And this statute has received a lot of press coverage and a lot of negative fanfare from the employer community. What it essentially did was codify a case known as Dynamex, which made it much harder for California employers to classify workers as independent contractors. It promulgated what's known as the ABC test, and that ABC test essentially provides that workers are employees unless the company can establish that they do three things, A, B, and C. The first being provide services outside of the company's control, that they're performing a task outside the company's normal business. And that prong is particularly difficult because a lot of companies like to use independent contractors to perform work that is within the main thrust of their business. And then C is have demonstrated a decision to actually go into business for themselves. But prong 2 or prong B is really causing a lot of problems for companies who were viewing a lot of their workforce as independent contractors and have to now reconsider those designations. The statute does have a series of exemptions, and I've listed those out on the slide. I don't need to read them to you. But as I think about the sports and fitness industry in particular, I think that there are really 4 that kind of stand out that you might want to know, maybe a few more. But the human resources component, marketing, graphic design, and direct sales are exemptions to this ABC test, but it doesn't mean that if you have workers who perform those functions, they are not employees. What it means is they're subject to the old test, which is a collective of sort of 11, I believe, non-determinative factors that are considered in the totality of the circumstances when viewing whether the company has control over these positions. But I want to flag the direct salesperson's exemption because I've had a lot of clients who are sort of glomming onto that and saying, well, that's a big group of our workforce who, we think we're now in the clear on and don't have to designate as employees because, they're selling and they're independent contractors, and that's an exemption. Unfortunately, the word direct is really important in that term, direct sales people. And if you're selling to a retailer or a wholesaler, you're not going to end up qualifying for this direct sales exemption. What that exemption is really looking at is individuals who are going in the home or going otherwise to direct users and selling items, and their compensation is substantially all, if not all, tied to their sales efforts. And so the direct sales exemption, I think, has caused a lot of confusion and sort of misplaced hope that sales forces can be left as independent contractors, and I think it's going to give rise to a lot of new litigation under this unwelcome statute. Uber and Lyft and a lot of the gig economy are pushing back and are filing lawsuits challenging the constitutionality and the freedom of contract under this statute. But as of right now, it is good law, and it took effect January 1st. With that, I'll hand it back to Tim.
Okay, our next topic is AB 51, which relates to arbitration agreements. And this is also a very, very controversial legislation. This was something that was presented to prior California Governor Jerry Brown, I think in 2016 and again in 2018. And he vetoed it both times because he determined correctly that it was preempted by federal law, the Federal Arbitration Act. The new governor, Gavin Newsom, decided to sign off on this legislation. It's very cleverly worded, and by that I mean it's the legislation itself is no more than 2 pages, and in those 2 pages it doesn't mention the word arbitration at all, except when referring to not being applicable to agreements that are enforceable under the Federal Arbitration Act. So it's cleverly worded in an effort to attempt to avoid federal preemption. But I'll get to that in a second. This is really a kind of a bad news and potentially good news situation. The bad news, of course, is that the law was signed into law by the governor, and based on the language of the law, went into effect January 1 of this year. And what it means is that mandatory arbitration agreements covering the Labor Code or the Fair Employment and Housing Act claims are unlawful. Mandatory means that if an agreement is required as a condition of employment or receipt of employment benefits, then the agreement is mandatory. And the statutory language says that it's mandatory even if an employee can opt out of it. So it's very problematic for employers that want to maintain an arbitration agreement, as most employers should. The one exception that is really critical is that the law specifically says that it does not apply to agreements, quote, otherwise enforceable under the Federal Arbitration Act, unquote. That's key because the FAA requires interstate commerce in order to apply. And it requires employers to be involved in interstate commerce, which is a very low standard, one that's normally easy to meet just through the stream of commerce of goods and services over state lines inside and outside of California is an easy test for an employer in California to meet. And if it does apply, if the interstate commerce does apply, and that means that the FAA governs the arbitration agreement, and the mandatory arbitration agreement under the FAA would still be allowed and enforceable under California law. So the key there is whether your company engages and is involved in interstate commerce, and if so, your arbitration agreement should specifically state that it is governed by the FAA, and if in fact it is governed by the FAA, then this new California law would not be applicable. In addition to that, employers are still allowed to have purely voluntary arbitration agreements. There may be occasions when employees, may agree voluntarily, not as a condition of employment, but voluntarily to pursue their claims in arbitration, as opposed to in state or federal court before a jury, simply because they may think that it's quicker and cheaper and simpler and all that. So it's still allowed. You're still allowed to have a voluntary arbitration agreement. California also, this California law does not apply to arbitration provisions in post-dispute settlement agreements or negotiated severance agreements. So those are still allowed. Now, the good news, though, is that this law, which was set to take effect on January 1, has not taken effect because of litigation activity by the U.S. Chamber of Commerce and the National Retail Federation. Those two entities were parties to a lawsuit filed in Sacramento in the Eastern District, the federal Eastern District of California. They filed a motion for a temporary restraining order to stop this new law from going into effect and for a preliminary injunction, and that was filed in around the middle of mid to late December. And on December 30th, just 2 days before the law was set to take effect, Judge Kimberly Mueller of the Eastern District in Sacramento enjoined the state of California from enforcing this law, finding that the business groups raised serious questions about whether it was preempted by federal law. She also had a hearing, I think, it was on January 10th, so last Friday, and she concluded that hearing by extending the TRO until January 31st as she further considers the U.S. Chamber's motion for preliminary injunction. She gave the state 1 week to supplement its arguments, with the Chamber's reply due by January 24th, and then there's going to be another hearing on January 31st, so 2 weeks from tomorrow, and hopefully she will grant the preliminary injunction and enjoin the enforcement of this new California law based on federal preemption under the FAA. The other new arbitration law to consider is SB, that's Senate Bill 708, relating to the failure to pay fees. The legislature noted that it was a common problem in arbitration, or perceived to be a common problem, that employers would force employees into arbitration, and then if they didn't like, the arbitrator or how the process was going or the claims being asserted or something, they would just decide, we're not going to pay for this, we're not going to pay the arbitrator, and that just brought the whole process to a halt. Not sure if that was really a problem. I don't think that it was, but the California legislature, as I think everyone on this call knows, is hostile to arbitration in California as a means of resolving employment-related disputes. SB 708 says that if an employer fails to pay required arbitration fees, either at the initiation of arbitration or during the pendency of the arbitration, within 30 days of the due date, the employer is in material breach of the arbitration agreement. And the effect of that is that the employee may either proceed with the claim in court or obtain an order requiring the employer to pay and continue in arbitration, along with an order imposing various sanctions, including monetary sanctions, evidentiary sanctions, and potentially terminating sanctions. So this particular new law has not been enjoined and is not the subject of litigation. So this is effective, or did go into effect on January 1, 2020. I'll turn it back over to John now for further legislative developments.
So the independent contractor law and the arbitration law, I think, are probably the two changes that have received the most sort of scrutiny, but by no means are they the only two sort of unwelcome changes for employers in California. AB 749 is the first of the next set that we're going to go through, and that has required employers to not include no rehire provisions in their settlement agreements and severance agreements. No rehire provisions up until this point are very common for employers not wanting to bring back someone who has, made internal complaints against them in the exit process and negotiated a severance. That generally now cannot be done. Those provisions are deemed illegal and can risk undermining your entire severance and release agreement. There is an exception. If you're settling with an employee who has been found by the employer to have committed sexual harassment or sexual assault, you can include a no rehire provision. That limited exception, I don't think, will come up in most cases, but when it does, or when it arguably does, what we are advising our clients to do is to include some reference to at least the investigation into the alleged sexual harassment, sexual assault in the recitals portion of the severance and or settlement release agreement. Oftentimes, the individuals entering into these agreements will not contractually agree that the employer found them to have committed sexual harassment or sexual assault in anything that they are willing to sign. But the next best thing is to include a recital concerning the employer's investigation into alleged inappropriate conduct, harassment, sexual assault, to the extent you are attempting to include a no rehire provision, and certainly a severability provision you'd want to accompany that no rehire, meaning that if that provision is found to be unenforceable, the rest of the settlement and release agreement will still be enforceable, particularly the release. Turning to the next statute, our California FEHA statute is the sort of Title VII equivalent for harassment, discrimination, retaliation claims in California. It includes a one-way attorney's fees provision for plaintiffs, and historically it's had a 1-year statute of limitations to file an administrative claim with our Department of Fair Employment and Housing, which is a mandated prerequisite of exhausting administrative remedies by filing that claim. And what most plaintiffs do is they file the claim with a request for an immediate right to sue, and after they file the claim with the DFEH, they then file the lawsuit. However, the new statute, AB 9, has provided that the employee now has 3 years to file the administrative claim and then 1 year thereafter to sue. So essentially, in a state where we already have a very high prevalence of discrimination, harassment, retaliation litigation, the window for potential claims is now open another 3 to 4 years. You may not know about a claim that's coming your way until 4 years after the incident. While DFEH claims are supposed to be served on the employer, oftentimes they're not. So once that administrative claim is filed, you might not know until the actual lawsuit is filed a year thereafter. So this is not a statute, I guess the one silver lining of this statute is it's not reviving claims that have lapsed. So if you had a termination in 2017 and the employee did not file a DFEH charge in 2018, they don't now have 3 years to file that charge. Okay, turning now to the sort of advice that we're giving in connection with this reality is records retention has always been important in California, but in terms of personnel-related counseling and documentation, you not only want to increase your prevalence of using a heavy pen, quite frankly, to document the coaching that you're giving to employees, but you're going to want to ensure that you're keeping this documentation of the employee counseling around for at least 4 years, and quite frankly, I counsel my clients to keep it around for at least 7 years. Lactation accommodation is the next area of legislation in 2019. Employers must now provide a private space other than a bathroom for employees to express milk. Employers need to also provide a sink and refrigeration, essentially storage accommodation for the lactating employee. If a lactation break is not provided, it's now viewed as being akin to a meal or rest break violation, and it is accompanied by a premium of 1 hour that is due to the employee. But that is not to say that the lactation accommodation break that you need to provide to employees is limited to their meal and rest breaks. Under the statute, they need to be provided as necessary according to the employee. So if the employee says they need to express milk, you need to provide them with the break time and place to do that, in addition to having a policy, either in your handbook or freestanding, that addresses employees' lactation rights. If the employee is taking a lactation break in excess of their ordinary 10-minute paid rest breaks under California's ordinary rest break law, that time does not need to be paid. But the initial 2 will be paid time on the clock, 2 assuming an 8-hour day, and the time still needs to be provided for subsequent lactation. CCPA under AB 25. CCPA stands for the California Consumer Privacy Act, and this is one of those statutes that we could spend an entire presentation going through for you. But from an employment perspective in California, it was sort of a gotcha statute in that the original draft of this statute in 2018 was limited to consumers and wasn't clear as to whether it was going to cover employers. But the final iteration did cover employers and employees within the ambit of consumers. Unfortunately, the statute, which requires you to disclose the categories of personal information that is being collected for a consumer or for an employee, was really written with an eye towards consumers. And so the impact on employers is unclear from a compliance standpoint. What exactly the purposes, for example, would be that an employer would need to disclose. What we are advising our clients to do is to essentially take your best shot and say that we're collecting this information for the purpose of considering hiring, promotion, compensation, reassignment. But it's very unclear. And what should be known is this is addressing companies with an annual revenue over 25 million. So it's at this point not impacting the sort of smaller employers, but the data that needs to be collected is sort of, the standard identifiers. When I say collected, meaning if you're collecting this data, you need to provide notice to the employee, name, address, social security number, driver's license. But it gets a little more interesting as you go through the list. If you're collecting gender, race, age, notice needs to be provided there. Geolocation data, for example, if you're using GPS services with your employee, that needs to be disclosed. Biometric information is one of the bullet points that slipped into the statute, but I know in Illinois there's been a huge rise of biometric privacy class action work, and I could see this new CCPA amendment giving rise to a whole new class of biometric class action litigation and PAGA litigation in California. Biometric information is facial geometry, retina, iris scans, which a lot of companies are starting to use for their timekeeping software to avoid time theft, employees clocking in and out for each other, that sort of thing. So again, there needs to be a notice provided to employees under the CCPA, but the contents of that notice hasn't really been specified, at least not to my satisfaction, for what employers need to do. So we are taking essentially a best efforts approach at giving a comprehensive notice to employees and applicants when this type of information is being collected on a case-by-case basis. There was a little bit of a reprieve towards the end of the year in terms of other requirements of the statute that were clearly designed to impact the consumer relationship and not the employment relationship. There is a provision in the CCPA regarding consumer requests for information and consumer requests to opt out of having to provide the information, which would not be tenable for an employer to comply with. That has been postponed until at least 2021, but it is conceivable that those provisions would take effect for employers in 2021. I will say that the legislature has advised that they are in the works of coming up with an employee-specific privacy bill that would supplant these provisions of the CCPA going into 2021, but we haven't seen a draft of that. There's been no rulemaking announcement or anything on those lines, so we'll just have to wait and see. But right now, the major takeaway is if you're collecting any of this information, you need to be providing your employees with notice. Organ donation. This includes both organs and bone marrow, and there are different requirements for both. Under the prior law, as you can see, the employers must provide up to 30 business days of paid leave in a 12-month period. That is still the case, and employers must provide an additional 30 business days of unpaid leave in a 12-month period for an employee donating an organ. Under this law, the employer can require the employee to use up to 2 weeks of accrued PTO, vacation, and sick leave first before kicking in the paid and unpaid business leave if the employee has an accrual of either of those things. There are also, like I said, bone marrow provisions, which are not as expansive in terms of time that's provided, but if an employee is donating bone marrow, they're entitled to 5 days of paid leave under the law. And similarly, the employer can require that the employee first use up to 5 days of earned but unused sick leave, vacation, or paid time off for bone marrow donation before providing the 5 days of paid leave thereafter. Again, this leave is not concurrent, used at the same time, evaporating both at the same time with the FMLA and CFRA leaves. Moving on, AB 673 addresses statutory penalties for late payment of wages. This is distinguishable from the waiting time pay at the end of termination. What this is talking about is, normally for a non-exempt employee in California, you have to pay their paycheck either biweekly or semi-monthly, and if those paychecks are not paid on time, previously the labor commissioner could seek $100 in penalties for the first violation and $200 per subsequent violation per employee, and now that is a claim that can be brought on an individual basis in a civil lawsuit by an employee. So we fully expect that new Labor Code 210 claim to be added to all of our class actions. Similarly, the Senate Bill 688 now expands the Labor Commissioner's authority to hold what we call Berman hearings or investigations, basically administrative actions for the recovery of contract wages, not simply claims for minimum wage and overtime. So if you have a contract for X amount of compensation, an employee can take a claim under that contract to the Labor Commissioner now. So it basically expands the authority of the types of claims and the types of allegations that a Labor Commissioner can hear. And I don't know how many of you know this, but the Labor Commissioner's office tends to be fairly pro-employee in California. And Tim is laughing, justifiably so. All right, turning the page to sexual harassment training. Sexual harassment training requirements in California have become more stringent and imposed more compliance obligations on employers in the last year. The training requirement is now expanded to employers with as few as 5 employees, and it has added the requirement of providing a single hour of training to non-supervisory employees, where it used to be simply a training that was required for your supervisors. Compliance was supposed to initially have been the first of the year, but the deadline has now been pushed to the first of next year, meaning the training needs to be done by the 1st of January 2021, or employers will be in violation of the statute. The requirements specifically are, as you can see, supervisory employees need to receive 2 hours of training by January 1st, 2021, and then receive that same training every 2 years thereafter. Non-supervisory employees need to receive 1 hour of training by January 1st, 2021, and every 2 years thereafter. New hires and newly promoted, whether supervisory or non-supervisory, need to receive this training within the first 6 months of their employment. Supervisors get 2 hours, non-supervisors get an hour. Oftentimes, we have smaller clients who are just doing 2 hours for everyone, but a lot of the content in the second hour is specific to supervisors and not necessary to non-supervisory employees. In terms of content, the DFEH does give some assistance on their website of arguable value, I would say. So this is new, hairstyles. Where this is coming up is in employers' dress code and appearance standard policies. I think the best way to describe it is if you have a policy that outlaws or forbids certain hairstyles such as dreadlocks, braids, and twists, you can now be held liable for discrimination against a person because those traits have been viewed as being associated with certain protected characteristics from a race and national origin perspective. Turning to OSHA. So OSHA requires immediate reporting of serious injury or illnesses, and that definition used to be someone hospitalized for treatment for at least 24 hours. That 24-hour requirement has now been eliminated. So OSHA needs to receive immediate reporting of an injury that requires any hospitalization for treatment. Now, the one caveat is treatment. It's not hospitalization for observation or diagnostic testing, But if something happens that requires one of your employees to go to the hospital for treatment, that needs to be reported to OSHA, even if they're there for 6 hours. Turning to Senate Bill 83, we have now expanded paid family leave benefits effective July 1st, 2020, so the middle of the year. Employees can get paid family leave, wage replacement benefits for up to 8 weeks instead of the 6 weeks, which it is currently, when taking leave to care for a family member with a serious health condition or to bond with a new child. This can also be used for qualifying military spouses, and watch for this number to increase in 2021 and 22. And the initial indication is that baby bonding will increase to 6 months of benefits by 2021-22. Okay, everybody's favorite question has to do with what's minimum wage where I employ my people. For employers with 25 or fewer employees, the baseline minimum wage is $12 an hour. And if you have over 25 employees, it's $13 an hour. But that is only part of the story, because we have municipal ordinances throughout most of California that provide for higher minimum wages. For example, in LA right now, I think it's $14.25. In San Francisco, it's over $15, I think $15.59. San Diego is up to $13 for all employees, you know, regardless of 25 or fewer or 25 or more. Santa Monica goes to $15 an hour on July 1st. So what you really need to do is look at where you are employing your workers in California, because there are numerous different requirements that go above and beyond the state minimum, and the state minimum is higher than most states in the country. The other impact this has, before changing slides, is that we have exempt classifications of employees, and one of the tests for most of the exemptions, other than the outside sales exemption in California, is a minimum salary requirement that is tied to minimum wage. So with the minimum wage increasing this year to $13 an hour, now for an employee to be exempt, even if all the other requirements are met, you still have to pay at least $54,080. If you only have 25 or fewer employees, that number is $49,920, but that is a moving target in terms of minimum salary. As the minimum wage increases year over year, that number will increase year over year. But important to note that the municipal minimum wage does not impact that minimum salary level. That minimum salary level is based on the state minimum wage in effect for your company at that time. All right, this is a quasi-employment related development, but we receive a lot of questions from your organization regarding AEDs, so we thought we would give some discussion of AEDs, automated external defibrillators, and requirements for having them and things to know about them. This is by far not a fully exhaustive discussion of the AED issue, but since there are so many questions previously, we thought we'd at least touch on it. A couple of easy things to know right off the bat. Schools must have automated external defibrillators, AEDs. Schools just have to have them in California. Public pools is an interesting one. Public pools where the pool is being provided for a fee that is charged, there are two requirements. One, the proprietor of the pool has to employ a lifeguard, and for all pools where a lifeguard is provided and a direct fee is charged, an AED unit must also be present at the pool. Turning to other businesses, because the question we get is, do I have to have an AED? So certain buildings that are built or renovated on or after January 1st, 2017 have to have an AED on site. Business buildings with an occupancy of 200 plus individuals and assembly buildings of over 300 individuals both need to have AEDs on site. The question that you might get is, what's the difference between a business building and an assembly building? I think in practice and litigation, you're going to find that most buildings will be viewed as a business building. So I would, if I were exercising caution, I would have an AED if I had built a building for my business that had an occupancy of 200 or more, and I would have an AED. In terms of industry-specific requirements, health studios are currently the only non-medical setting in which California statutes or regulations require the AEDs to be provided. And so I imagine that some of you out there operate health studios, gyms, and if you don't have an AED, you should. There are specific training requirements that health and safety code lays out, 10.4.113. I don't think we have time to go through the specific training and utilization requirements, but I will say that a highly watched case called Jabo versus the YMCA of San Diego was decided in the last year or so, and it applied to a field that was operated by a YMCA, and the YMCA had AEDs on site at their building next to the field and would bring AEDs for their own events that were held on the field, but they rented the field to a local soccer team, and one of the individuals playing soccer went into cardiac arrest and died, and they didn't have the AED on site, and no one thought to get it and use it. And quite frankly, there was discovery in the case where the person admitted that they should have, according to the YMCA's practice. Well, the California Court of Appeal upheld the grant of summary judgment in favor of the YMCA after years of litigation, holding that they did not have a duty to have somebody there using the AED and responding to the crisis, and found no liability on behalf of the YMCA. So there are many of these Good Samaritan defenses written into these statutes. It's a glimmer of common sense. I think the overarching thought is it would be good, and the California legislature has determined that it would be good if more buildings had these, so that maybe lives could be saved in the event of cardiac arrest, but they did not want to increase litigation and punish people for having them on site. So as long as they are there and kept in working condition and the minimum training of personnel and requirements like that are met, civil liability will be stemmed, if not completely eliminated. I know that's a complicated area of discussion that I'd be happy to take offline with anybody, but we kind of have to move on from the AED discussion. And I'll turn it over to Tim.
Okay. Excuse me. I'll talk about a couple of important judicial decisions in 2019, some California Supreme Court and some California appellate courts. The first is a decision called ZB-NA versus Superior Court, referred to as the Lawson decision after the name of the plaintiff. In this case, the California Supreme Court held that an employee suing under the PAGA statute cannot seek unpaid wages as part of the penalties that may be recovered. As most of you probably know, PAGA stands for the Private Attorney General Act. It's a statute, California statute that was enacted in 2003 and has become the source of extensive litigation in California over the years, to the point now where I don't have any official statistics on this, but most likely litigation under PAGA now exceeds litigation brought as wage and hour class action. And the main reason being that under PAGA, based on a prior California Supreme Court decision in 2014, PAGA claims are not subject to arbitration because the PAGA claims are brought, the main party in a PAGA claim is the state of California. And so a decision held that because it's the state of California and the state never agreed to arbitrate, that somebody, a representative plaintiff bringing a PAGA claim, that claim cannot be, the employer cannot force that into arbitration. So what was significant here is that the dispute centered on whether the portion of the PAGA claim seeking unpaid wages was subject to the parties' arbitration agreement. As I mentioned, PAGA claims are generally exempt from arbitration, but individual unpaid wages claims may be required to be arbitrated, of course, depending on the arbitration agreement. Well, the California Supreme Court resolved that issue by holding that a plaintiff employee cannot recover unpaid wages on an individual basis in a PAGA action. So the arbitration issue is moot because it's in a pure PAGA representative action, arbitration is not allowed, and since there is no availability of unpaid wages on an individual basis, there would be no basis to compel arbitration of the unpaid wages claim. So this decision, which came out in 2019, resolved that issue and cleared up a lot of uncertainty and a lot of litigation. And now, instead of seeing PAGA claims in addition to claims by the plaintiff for the recovery of individual unpaid wages, now these claims are just limited to PAGA, the PAGA representative action, which is, of course, problematic enough, but resolves the issue of the additional potential recovery. The next decision I want to talk about is called Otto versus Co. It's also relating to an arbitration agreement and DLSE claims. This involved the issue of whether an employee could be compelled to arbitrate a wage claim pending before the DLSE. Those claims, as John mentioned earlier, are called Berman hearings. Those are administrative hearings before the California Labor Commissioner. Prior California cases, including the California Supreme Court decision in 2013 called Sonic Calabasas versus Moreno, held that arbitration would be enforced if it provided a sufficiently affordable and accessible forum to fairly adjudicate the dispute. The California Supreme Court was supposed to determine whether that standard was met in this case. However, the California Supreme Court never actually reached that issue. Instead, it concluded that the arbitration agreement in question involved such an unusually high degree of procedural unconscionability, coupled with substantive unconscionability, sufficient to render the entire agreement unenforceable. The procedural unconscionability in that case was unique in that the arbitration agreement, was in English, although the plaintiff, Co's primary language was Chinese. He was a piece-rate worker and was given very little time to read the arbitration agreement or ask questions about it. And of course, the California Supreme Court found that that was procedural unconscionability in the extreme, which rendered the agreement unenforceable. An important question, though, for employers emerges in the wake of this Otto case, which is whether it is worth it to jeopardize the arbitration agreement or the arbitration of more serious discrimination and harassment claims in order to secure arbitration of low-risk labor commissioner claims. In fact, why any employer would insist upon arbitration of a labor commissioner claim where potential liability is very limited remains a bit of a mystery. And of course, the arbitration agreements are, better to carve out these Berman hearings because of the, very limited potential liability and focus on more important claims that have more significant exposure, like discrimination, harassment, retaliation, and labor code claims. The next issue I want to talk about is reporting time pay and a decision called Ward versus Tilley's, a unique provision under California law that requires employees to be paid reporting time pay if they report to work as scheduled but are furnished with less than half of the expected day's work. Employees have to be paid for 2 hours or half of the scheduled day's work, up to 4 hours, whichever is greater. That's existing California law. Under this Ward case, though, the issue was about reporting to work. In the Ward case, the employer directed employees to present themselves for work by telephoning 2 hours prior to the start of a shift to determine whether work is available. And the court held that reporting time pay the reporting time pay requirement is triggered by this telephonic contact. Keep in mind that this is a California Court of Appeal decision. It actually conflicts with some federal court decisions in California on the same issue. So this issue has not reached the California Supreme Court. It probably will, but right now what we have is this California appellate decision. The key issue addressed was what it means to report for work in wage order number 7. The defendant Tilley's argued that report for work can only mean physically showing up at the work site, thereby excluding on-call shifts. The plaintiff argued that report for work encompasses any kind of reporting, whether in-person, telephonic, or otherwise. The court sided with the plaintiff, interpreting report for work broadly to mean presenting oneself as ordered. Report for work is defined by the party who directs the manner in which the employee is to present himself or herself for work, that is, by the employer. If an employer directs employees to present themselves for work by physically appearing at the work site, then reporting time is triggered when the employee reports but is sent home. If, however, the employer directs employees to present themselves for work by telephoning in, then reporting time is triggered when the employee calls and is told not to come in. In reaching this conclusion, the court found important defendants' practice of inconveniencing employees by narrowly restricting their activities during the window of time they were required to call and disciplining them if they did not, all to benefit how it staffed its stores. So that's an important decision to keep in mind, and it's problematic because it's sort of kind of a look into the future, and it's not in your materials here, but I'm going to talk very briefly about proposed legislation, just so you're aware of it. This is not actual, this has not been signed into law, but legislation was introduced on Monday of this week by a California state senator called the Fair Scheduling Act of 2020. Similar legislation was attempted in 2016 and 2018, and it never got out of committee and never made it to the governor's desk. But this bill, this proposed legislation, workers would be entitled to so-called modification pay if their shift gets canceled or rescheduled without advanced notice. They also earn wages for on-call shifts when employees are required to be available without the promise of getting called into work. The legislation would further require employers to hand out schedules at least a week in advance of the first shift on the calendar. Again, it's not actual legislation, it's proposed legislation, but it's something to keep an eye on because something like this in California is likely to be something that we're talking about as a new law a year from now.
Ironically, the rationale for that statute is to provide workers with flexibility, which they would have if the legislature hadn't passed AB 5 and allowed them to be independent contractors. Really quick, I'm going to go through just some major takeaways in the next few slides. There is a Boris decision by the California Supreme Court that is a welcomed slight ray of sunshine, which provides that wage claims are only to be brought under the California Labor Code and should not be accompanied by a tort of conversion. And the reason that matters is that it eliminates the recoverability of punitive damages for failing to pay wages. However, there are plenty of other avenues for penalties and whatnot for employers who don't pay wages. The rate of pay for missed meal and rest break penalties, there's a California Court of Appeal decision that was helpful in this regard. The premiums, oftentimes called penalties that you pay if you're unable to provide a 30-minute duty-free unpaid meal break or a 10-minute on-the-clock duty-free rest break, is an hour at the regular normal base rate of compensation, not the regular rate of pay. And those things are different. The regular rate of pay is what's used for overtime calculations and includes other types of remuneration in addition to the base hourly rate. For example, non-discretionary bonuses, non-monetary compensation like free meals, membership perks, things like that, which has led to a rash of regular rate litigation. In overtime cases, that is not the applicable hourly rate, at least according to the California Court of Appeal for the premium. Dynamex, is it retroactive? A Court of Appeal has held that it does apply retroactively. What we're certainly finding is that what we certainly know is that the exemptions are retroactive. What remains to be seen, but I'm not betting in favor of employers on this legal issue, is whether AB5 and Dynamex, the ABC test that we talked about at the outset, will be found to be new law effective only January 1st. I think when assessing workers, they're going to use this test going back retroactively, even before the Dynamex case and AB5 legislation. Okay, a little bit more good news on the Labor Code 226 case. An employer, 226 meaning the inaccurate wage statement cases, using a DBA or a fictitious name to identify the employer on a wage statement, or not including the 4 additional digits with the zip code on the employer's address, is not an actionable inaccuracy in an inaccurate wage statement claim now, according to the California Court of Appeal. Okay, I think we have hit a point of stopping. I know that you all have the copy of our PowerPoint deck, and from here on, it's really a series of recommendations that we've gone through on the prior slides. But if there are any questions now, I know Tim and I are willing to stay on late. Allie, have you received anything that you'd like us to address?
Thank you so much, Tim and John. This is Allie again with SFIA. We did have a couple questions come in. First question, do the employment laws covered here apply to employers whose principal place of business is in another state but has employees living/working remotely in California?
So I think the question was, does it apply to employers based in other states who have people working in California? The answer there is yes. It really depends on which statute we're talking about and the amount of time. A question that comes up oftentimes is, I've got an employee who lives in Nevada. I, as an employer, am based in Nevada, but every once in a while the employee sort of bleeds over the border. What usually happens in those situations is there's an assessment of whether there is a significant amount of time that is spent working in California as to whether the California laws apply. But know that judges and the DLSC in California tend to err on the side of finding workers to be California employees bound by California law.
Got it. Thank you. Next question. For something like the lactation law, If a company has less than 50 employees, they do not need to accommodate, correct?
No, that's actually not correct. If you have less than 50 employees, you may apply for an undue hardship showing to the DIR, which is essentially the Department of Industrial Relations, the DLSE. It's the entity that these Berman hearings are brought to, but also provides oversight in California. So it's a group of people who could get out of it with the requisite showing, but an application needs to be made. Does that make sense?
Got it. All right. Okay, the next question is a little bit long, so bear with me. My business involves streaming audio workout classes via a mobile app. We purchase our recorded workout content from independent contractors and are wondering whether if we contract with folks in California, there is a risk they'd be considered employees. One could say that our core business isn't producing content, it is delivering to consumers. But our fitness content is a little different than the licensing fees for our music, because the fitness content is being made specifically for us and we're purchasing the exclusive license to it. We are a Delaware corporation, if that matters, and our app is available in all 50 states.
Okay, so all of the qualifiers in that question, not to be coy, but those are things that we would argue in litigation for why those particular workers are not employees and why they're independent contractors. I'm not sure if I 100% understand the hypothetical, but if I rewrite it to answer the question, I think the concept was there are people in other states providing material on a freelance basis to this particular employer who's then selling it in California. I think that is a better and more defensible case than the opposite, which is where you have the freelance providers working in California and providing it to the employer for use anywhere. I don't think the point of sale and distribution is the determinative factor. I think it's where the work is being done. That is the most important sort of threshold factor before assessing whether the AB5 statute even applies. So if you've got a Maryland instructor providing content to you that you then stream and send to California, I think that that's less likely to be a problem of misclassification than somebody in Los Angeles sending you the content that's being provided either in California or elsewhere.
We also just received a follow-up on that question. So you guys are on the same page. They said correct. However, what if the suppliers of the material are freelance living in California?
So there are unique provisions for freelance content providers in the exemptions to AB5. I will tell you they are not well received by the freelance community because there are caps within the exemption that provide that a certain number of pieces of content may be provided, but if to one contracting business, but once you exceed that number, then you're no longer qualifying for the exemption. I think that number is 35 pieces of content. I don't want to have everyone rely on that without me checking it, but I think 35 pieces of content is the exemption.
All right.
So
the next question, though, I think this is going to be our last time. Oh.
Yep.
The question is, does the new AB contractor law apply to contractors that live outside of California, even if our company is based in California?
No, unless they come into California to provide work and services. That was an easy one.
Great. Okay. So that's going to be it for questions today. Thank you everyone so much for joining. wonderful presentation from Tim Freudenberger and John Giovanoni. If anyone wants to get in contact with Tim or John, their contact info is listed on the final slide of this presentation. This concludes today's webinar. Now, most importantly, please remember to fill out the 2020 State of the Industry survey. This survey will be included in the follow-up email to this webinar, and that we will be sending all attendees within 24 hours. This follow-up email will also include a link to the webinar recording and its slides, so please keep an eye out for it. We look forward to having you join us for future SFIA webinars. Thank you all so much and have a wonderful day.
Thank you.
All right, thank you.